I'm Colin Zick, a partner at the Boston-based law firm Foley, Hoag. I practice in our healthcare and administrative law sections working on healthcare regulatory and compliance matters. In terms of the rights of physicians to privacy online, I'd say they have very little and probably less privacy than ordinary members of the public have. I would say this based on a number of recent examples that we've seen that show that because they're part of a regulated industry, government really has the right to and is actively looking at patterns and practices of behavior. Private industry is looking at their patterns and practices of behavior, and individuals are making the patient-physician relationship public in ways that hadn't been thought of in prior years. In the course of my practice, I've come across several times now, physicians have come to me and they've complained that a patient has put a listing up on a review website, and there's something about the review that's not true, it's false, or even they think it's defamatory. And it really can be quite difficult to get these things removed because the way that the federal laws which govern these things are written, there is protection for the provider of the service so long as they're not really involved in the review itself, that it's a third party posting the review. In order to have success at getting rid of those, really, you have to understand what those laws are, try to tailor your request to these companies around those laws, but also just try to make as forceful an argument you can that the situation is unfair and point out how it probably in the long term is bad for that website to have those kinds of reviews on their site. That's what proves successful. It's not taking somebody to court, but really trying to persuade them that this isn't something that they want on there. Argued this week in the Supreme Court was a case involving some rules from the state of Vermont, which would, if they'd gone into effect, would have prohibited pharmacists from releasing prescription information about physicians. We all know and understand that an individual prescription for an individual, that can't be released. That's confidential. But the overall aggregate patterns of prescribing can and frequently are released. What Vermont did as part of an overall attempt to clamp down on pharmaceutical company marketing in its state, it said we're no longer going to allow pharmacists to share prescribing data with pharmaceutical companies. So they passed a law to that effect. The law was challenged in the Federal Court of Appeals. The challenge was upheld. The case is now in the Supreme Court, and at least if you read the tea leaves of the oral argument, there seemed to be a number of justices who were hostile to the restrictions that would place on commercial speech and exchange of information. So it may be that when we get that decision, and that'll be out before the end of June, that we see that the Supreme Court sides against doctors and the privacy of their own patterns of practice and in favor of more disclosure about those sort of patterns of practice. Well, HIPAA relates to individual information, what is defined as individually identifiable health information, which then through the HIPAA regulations is defined as protected health information. It all revolves around an individual, and it's an individual privacy right. There isn't a statute that says the privacy right exists with physicians. And if you look at any of the state case law, that's the same for the state laws that were in place before HIPAA and that still exist to some extent. So there really isn't a right there for the physician to keep his or her practices private. The right lies with the individual. And once you take off the identifiers for that individual, either by stripping that information or aggregating the information, at that point, there really isn't a right to privacy. As part of healthcare reform, we've seen a great push at the federal level to having electronic health records in place. Everybody thinks that's going to improve quality of care and possibly reduce cost. Whether that actually happens remains to be seen. But there's certainly this push on their incentives at the federal level. Millions of dollars are being paid out to physicians in order for them to adopt electronic health records. Now, in order to get that money, you have to meet a standard called meaningful use, and I won't go into everything that constitutes meaningful use, but part of that test is that the government's going to look at the way you practice as a physician and make sure that you meet certain kind of milestones or certain kinds of checklists that you do certain things which are deemed to be good for patient care and good for quality of care. But what this means in the larger sense is that the government is now supervising more of the care that individual physicians are providing, and ultimately you're going to see that it's going to stop paying for care that's provided in ways that it doesn't like or doesn't recommend. And so the freedom of physicians is going to be reduced all through this process. It's something that not a lot of people have talked about because they see the upside right now. They see the government paying to help for the adoption of electronic health records, and they see how that interchange can be helpful. But they haven't focused on the downside of that for physicians.